So now that you know how to make an outline of your course, you are ready to take the final exam. Of course, assuming that you've done studying in the meantime. But still, the question persists. What should you do once you get the exam question? Should you just jump in? Should you just start writing? And for many people, this will be, a very instinctive response. Once you're prompted with a question, you just want to give your answer as soon as you can. I think, however, that there are some strategies you should deploy and that you should think a little bit about the process. You should maximize your efficiency during the exam itself. So here are a few things I would take into consideration if I had to take a legal exam myself. So the first thing I can say is you should read the whole problem very, very carefully. Now, I want you to read the facts of the case without necessarily thinking about the questions or the law or anything else. Just read the facts for what they are. Read it as if it were a mock exam, or as if it were a novel, or as if you were about to retell the events of a case to a friend. So you need to start by getting familiar with the facts of the case, and the best way to get familiar with the facts is not to jump to any conclusions about the rules, which might or might not be applicable, but rather just read the case slowly and in as objective of a way as you can. Now, once that is done, you want to read the questions. Once you're familiar with the facts of the case and you've used, let's say, anything between 10-15 minutes to slowly read the facts of the case, you want to read each of the exam questions individually and slowly and several times. So you should budget your time as to allow you to just sit down and calmly read all the exam questions without actually writing anything. Just read them and get the idea of how they actually relate to the facts of the case. Now, this initial step, just reading the case and reading the questions, sounds very obvious, but again, believe me when I say that it's not, that people very often overlook some parts of a question. So anytime, if you have any time at all on the exam, you should use it to read the facts and read the questions, read them separately, read them jointly. I've probably said read way too many times by now, but this truly is a crucial step in the process. Just read, nothing more. After that, I think the next step in the process is to take your course outline and then identify the relevant parts on the course outline. And you will be able to do this based on the way in which the question is phrased and based on your substantive knowledge of the law. So we saw already in one example that we could ask a question whether or not CISG is applicable. If you were taking a course such as International and Commercial Law, if you got this very long exam with lots of facts and you immediately see that one of the questions is CISG applicable, you would know that the part of your outline, the part of your notes that you should refer to is this part which we drafted together, is this part which talks about material scope of application and which talks about exclusion criteria. So basically just scroll through your entire outline or flip through it if it's an open book exam. I believe that most exams which you would be taking nowadays will be open book exams. You would be allowed to take in your outline. And then during these exams, so just remember to identify the parts of the outline which are relevant for your exam. Remember, by this stage, by the end of the course, your outline could be pages upon pages long, probably 30 plus pages for very detailed notes backed by examples, as we talked in another video. So just use some time to connect the course outline with the questions on the exam. How can you actually connect them? How can you do this? How do you put together your notes with the content of the exam? I think that this is entirely up to your personal preference. One method would be to use a highlighter or to just take notes on the text of the exam itself and on your outline in parallel. So for instance, I could use a yellow highlighter to highlight some parts of my outline which talk about applicability of the CISG, and then I could use the same highlighter in my exam to highlight the parts which are relevant for the applicability of the CISG. For instance, if personal use is what I see is relevant for my outline, then I might want to designate it as such in the exam text itself. I mean, another way would be to, I guess, just take notes directly in the exam text without any underlining or anything, or vice versa. You can just use your outline and write in some of the facts from the case there. So that would be a way of turning the process around. You need to find what works best for you, how this connecting of the law or of the legal rules which you have learned about in the course with the facts is most efficient in your particular case, what you feel most comfortable with. But this is where mock exams and this is where previous year's exams come in super useful. So in most legal courses, you will have access to previous year's exams, or your professor will give you some materials to practice with. You should use those before the exam to actually simulate the exam environment and to, well, in essence, try out this process, see how you can identify the relevant parts of the outline and connect them to the exam answer. Why is this step crucial? Well, because it will allow you to do the next step. It will allow you to draft a brief outline of your answer. So instead of writing immediately, even now, you should have a short list of bullet points which will form an outline of your answer. So we've already seen one good exam answer pertaining to the CISG. We can think pretty much the same thing would apply if we had another type of a legal problem, like something in privacy and data protection or copyright law or any other legal area. So you might want to use some kind of an outline for your answer. And you see a few examples, which I have. Again, treat them just as examples. But remember that before you start writing, you might want to have a very short bullet point outline of your actual text. Once you have this list, it's not going to be super hard to actually expand the text. This is, at this stage, it's just a question of time. Turning this list of bullet points into actual legible text is just going to be a function of time, nothing more, because you know the rules, you know how these rules apply to the facts of the case, you have already drafted your answer, you just want to substantiate it. So actually writing out the exam, once you have gone through these steps, is going to be so much easier. And then I would say completely at the end of the exam, once you're done with the writing out of your exam answer, think a little bit about presentation and formatting. Headlines or headings are your friends. If the exam answer is short, so are italics. You want to emphasize certain points in your exam. Now, you have to remember that your exam is going to be one of the many exams on the same pile. You want your exam to stand out. You want somebody to be able to just take a quick look and immediately understand that you got that structure perfectly right and that you actually know how to apply the law to the particular case in question. So I'm not saying go crazy with the formatting. I'm not saying use all of your time to, obsess about the margins and font space. All I'm saying is, even if you're delivering a plain text answer, there are ways to make those elements which you have on your outline stand out and be easily identifiable, easily legible. You want to make your exam appear professional. This is, as I've said, somewhat counterintuitive of an advice, because most people would think that there is no way they have any time on the exam to do this. I'm saying it's, about finding some sort of a balance. If you are entirely out of time, then don't do it. But if you do have any time left, then use it to fix the formatting and presentation. Use headings, use bold or italics for emphasis, emphasize keywords, emphasize the elements, because it's going to make your exam appear way more professional. And if you don't know how to do that, a great approach would be to read a few legal memos filed with the courts or read a few judgments. You will usually see that those tend to be structured in a very good way, and you can just try to emulate that structure on your own exam. So, long story short, the most important takeaway is not to jump into the writing immediately, but rather spend some time to familiarize yourself with the facts of the case and with the questions. Spend some time to identify critical parts of your outline, connect this outline to your exam, draft a very short answer and then expand finally on that answer while fixing the formatting. It sounds simple, but it does require practice. Think of it as as any sport, basically. I think that the more effort you put into practicing this process, the easier it's going to be on the final exam. Not just based on your substantive understanding of the law, but by being more familiar with the methodology, by being more familiar with how to identify the relevant parts of an outline, how to use them for your exam answer, you are going to speed up the process and you will give yourself more time to think about different issues. So sorry if this was way too quick, but I hope that it was still useful. And then I will very much like to talk about some things you should not be doing on your exam as a direct consequence of the things we've discussed both in this video and some of the previous videos.